So I'm just gonna slowly start with a warm welcome from Heidelberg. I see participants are still dropping in, so we're in no rush to get started, but I can tell you that I'm super excited for this panel discussion that we're having today. My name is Franziska Plümmer. I'm a senior researcher at the Max Planck Institute for Comparative Public Law and International Law in Heidelberg, and I'm the organizer of this human rights discussion group. We organize biannual events on current human rights debates, and for today, I'm particularly delighted that I'm able to host this panel of 4 experts that are well versed in the asylum and human rights debates. They will introduce you to current developments and discuss European asylum practices in a global perspective and reflect on the political and legal efforts to deal with the current situation. And I think that this talk on territory and refugee protection, places for human rights, is particularly interesting in the setting that brings together a variety of disciplines and also geographic focus. I'm trained as in international relations and political geography, and in my conversations with colleagues from the legal field, the concept of territoriality, zones of exception or suspension that I would use to investigate these recent phenomena of transit zones or extraterritorial processes raised a lot of eyebrows. So I think it's particularly interesting to have this this cross-disciplinary exchange. And I think this expert panel will help us in thinking about how to tackle territorial aspects of asylum practices and human rights. So let me shortly introduce the panelists. First, we have Pauline Endres de Oliveira, who's a research fellow at the Justus Liebig University of Gießen. She's part of the PROTECT project that explores the legal implications of the United Nations Global Compact on Refugees and Migrants. Within the project, she focuses on safe and regulated access to protection in the EU. She also teaches in the Refugee Law Clinic at the Humboldt University of Berlin and also wrote a couple of pieces for our Völkerrechts blog. Then we are glad to have Nikolas from the Danish Institute for Human Rights. He works on refugee and human rights law. He wrote a PhD on bilateral cooperations in asylum. Currently, he works on the law of cessation for refugees, third country solutions such as resettlement and complementary pathways to asylum, and the role of the United Nations treaty bodies in protecting those asylum seekers. Also, I'm very happy to announce that Bonny Ling is joining us. She joins us in a dual capacity as a research fellow from the Institute of Human Rights and Business, but also as the lead of combating modern slavery in Portsmouth, City of Sanctuary. I know her extensive work on human trafficking in China and Asia, but she also writes on human rights, migrants, business responsibilities, and international law more generally, and has extensive experience in working also with these business and refugee communities. And finally, I'm thrilled to announce that Aleinikoff joined us for today. He served as a director of the Zolberg Institute on Migration and Mobility, and he is a university professor at the New School for Social Research in New York. He has written extensively about immigration and refugee law and policies, transnational law, citizenship, race, and constitutional law. His government experience is as extensive as is his academic record. And among other activities, he served as the United Nations Deputy High Commissioner for Refugees and was a co-chair of the Immigration Task Force for Barack Obama's transition team. And his last book, The Arc of Protection, which he co-wrote with Leah Zamor, also deals with the question of sovereignty and human rights. So I think we're very lucky to have him here today. As a last announcement, we will record this event and this will be published on the Institute's YouTube channel. And yeah, as for the proceedings, we will start now with the inputs by our 4 panelists and then have a second round in which the panelists can again address each other or add something to their first input. And then we will have a round of Q&A. For that, everyone in the audience is very welcome to use the Q&A box where you can give questions. You can do that also anonymously, and you can vote up questions of other people that you think might be interesting, and you can sort of second that. And the panelists can either give answers in a written form, or we will take them up for the discussion in the forum. So then I would say let's get started, and the first is Pauline. So you have the floor. Thank you.
Thank you very much. Thank you for the invitation. I'm very excited to be here and look forward to the discussion. I'm going ahead and will share my screen. Just 1 second. So I will start with a brief input regarding the question of access to protection in general and refugee law, but also the situation in the EU, to then draw on some country examples of Germany, and then raise a question with regard to the correlation of access and rights, which I would be very interested to talk about further if we have time. So just to have everyone on the page what we're talking about, the numbers we're talking about, we have over 97 million people of concern worldwide, protection seekers worldwide, and a large part of them, and that's a point I would want to make here, 85%, is hosted by low and middle income countries because they are still in the regions. We have a very high number of internally displaced, and very many of those protection seekers are still in the regions. So with a view to that, let me briefly talk about the phenomenon I address as asylum paradox, a phenomenon that is all very familiar to everyone here in this panel. There is no explicit right to access a state to seek protection in refugee law. We have, of course, the principle of non-refoulement, giving an implicit access right as soon as a person manages to reach a border, but there's no explicit right. So while protection depends on access to territory, protection is territorial, access is effectively prevented. We see this phenomenon, this asylum paradox in migration and asylum law in the EU. On the one hand, we have territoriality of protection commitments, the international protection system, a comprehensive set of procedural rights, and we're watching over the quality of asylum procedures, but asylum can only be claimed at the border or in the territory of the EU. There is explicitly also no option to seek asylum at embassies provided at EU level. This has been emphasized on by both the CGU and the case X and X already in 2017, and then with a view to Article 3 of the European Charter of Human Rights, also by the European Court of Human Rights, just recently in the MNN case in 2020. If we have time, I'm happy to talk more about these two judgments, both concerning cases of families, Syrian families who applied for a visa at the embassy of Belgium in Lebanon to then be able to enter Belgium and seek asylum on the Belgian territory. So while protection is governed territorially, we have extraterritorialization of migration and border control. As Franziska also mentioned in the beginning, we have almost every one of these, this large amount of protection seekers I indicated, coming from countries who are on the visa blacklist for the EU, so they need a visa to enter, and there are no asylum visas, as I just said, and measures such as carrier sanctions, providing for sanctions for example, flight companies who transport individuals without necessary travel documents, enhance this this restriction and this deterrence. So with a view to that, my research focuses on safe pathways to protection as methods of maybe answering this asylum paradox, maybe even resolving it. And just to give a brief overview of measures that there's the resettlement program, which is a relocation program administered by UNHCR, specifically for particularly vulnerable people, but also for protected situations, protracted situations. That means situations in which people might have already reached a first country of refuge, but they cannot stay there on the long run. So it's part of one of the 3 durable solutions of UNHCR. But the resettlement places offered by the international community are not sufficient to meet the demand that we have with a view to the high numbers that I indicated in the beginning. So for example, in 2020, there were fewer than 35,000 refugees out of 20 million at that time resettled. And we have UNHCR indicated resettlement need for 2021 of 1.4 million. So I will come to the efforts of Germany to meet these numbers in a minute. Just to briefly point out that next to resettlement, we have complementary pathways, which are all humanitarian pathways other than resettlement. There are those with humanitarian purpose, for example, the asylum visa or humanitarian visas I just mentioned, which we find in exceptions in some national practices. We have larger scale admission programs, so temporary humanitarian admission. For example, the admission programs offered by Germany for Syrian refugees, which I will come back to in a minute. And then we have community and private sponsorship programs, which are admission programs which make the admission dependent on a financial guarantee by a sponsor in the future host state. And lastly, there are complementary pathways without humanitarian scope. In my work, I don't focus on them, but they're also very interesting in practice because they offer ways to safely access a state by, for example, education or labor mobility pathways or family reunification, or pathways which are not originally, they were not originally designed to offer protection, but they can in fact offer protection to individuals in the need of protection. So to now briefly give you an overview of what we have in Germany, what Germany offers in terms of safe pathways. There is the resettlement program since 2011 with a yearly quota of 500 people. And very newly introduced in 2019, we introduced the NEST program, Neustart im Team, New Start in a Team, which is a hybrid of resettlement and private sponsorship. Why is it a hybrid? It's individuals are offered the resettlement status, which is a fairly strong humanitarian residence status in Germany, but there is financial commitment needed by individuals in Germany who are already in Germany to be admitted through this program. It's not as large, the commitment, as in the private sponsorship programs that there are at federal lender level, but there is still a commitment needed, which concerns housing, 2 years of financial commitment for housing costs. And then we have national humanitarian admission programs. So at federal level, Germany can at any time initiate humanitarian admission programs on the basis of Section 23 to Residence Act. A very, very prominent example is the admission of over 20,000 protection seekers from Syria between 2013 and 2015. These programs were complemented by programs of the individual lender at federal lender level. We have Section 23(1) in the Residence Act, which allows the federal lender also to initiate such programs. A problem is that sometimes arises in practice that they need the federal level to agree. So a single Bundesland cannot go ahead and admit protection seekers just on their behalf. They have to agree with the Bundes level, with the federal level. A very prominent example is the admission of over 21,000 protection seekers from Syria from 2013 to 2015. These programs can be characterized as private sponsorship programs because all federal lender programs require a financial commitment for the admission of protection seekers, which is fairly large. It requires the sponsor to cover all costs except health insurance costs for 5 years upon the arrival of the respective person. And lastly, we have the humanitarian visas, which I said were voted out, I say, by the European courts to exist at European level. But we have them at national level in Germany. There's a section providing for a humanitarian visa in particularly exceptional cases. So it has to be a case really apart from every other situation in that country for an individual admission to Germany. Interestingly, this very particular and very exceptional provision has been applied just recently for the admission of Afghan local staff members to Germany until the end of August now to 2021. What gives rise to lots of controversy is that Germany said that they now closed the list for an evacuation of the German local staff members on the basis of this provision, which is odd because this provision does not offer this possibility of closing any list. It's an individual admission procedure that should be open at any time. Human rights lobbyists are therefore advocating for implementing national humanitarian admission programs at federal level on the basis of Section 23 and leave this route of the humanitarian visa open for exceptional cases, just as it should be. So after this overview, I want to point out a very interesting correlation that we have in German law, which might exist also in other countries, and which gives rise to a discussion which I would love to have with the other panelists as well, is that there is a correlation between access and rights. The protection status after arrival differs significantly whether one entered irregularly and entered the national asylum procedure after engaging in very life-threatening and dangerous flight routes. One can then apply for asylum and be granted either the international protection status, which would be the refugee status under the Refugee Convention, or if applicable, subsidiary protection status. And if neither of these provisions applies, one is granted a national protection status. If a person is admitted via a resettlement procedure or any humanitarian admission procedure, then there's only a national humanitarian status that can be granted. There is no option to be granted refugee status, for instance, arriving through a safe and legal channel. Why is that a problem? The problem arises because the refugee status is the strongest protection status in Germany. It gives the strongest resident permit. That means that refugees under the Refugee Convention are, for instance, allowed to reunite with their family members. Family reunification is not a problem per se. Also, they receive, for example, the refugee passport, which is a very important issue for many people who fled their country and cannot go to the embassies anymore. And these rights, for instance, are precluded in many of the national protection statuses granted after safe and regular arrival. So what can be observed is kind of a trade-off between access and rights, which one could argue is part of achieving a balance between state interests and the aim and the necessity to grant protection. Maybe it's a form of answering the asylum paradox by balancing out these interests, or maybe it's illegitimate because it doesn't really comply to protection needs. Either one, it gives rise to a discussion. And with this, I will close now. And I'm very much looking forward to the next inputs and to discussing further with you. Thank you very much for your attention.
Thank you so much, Pauline. Great. And then second, Nikolas, do you want to take the floor? Great.
Thank you very much. It's lovely to be with you today. I'm going to speak in a very low-tech fashion, so I hope you don't mind. I'm just going to speak to camera. And my brief today is to speak to the prospect of an extraterritorial asylum regime in Europe with a specific focus on the recent Danish approach. So in my 10 to 12 minutes, I'm going to try and do three things. Firstly, I'll give an overview of what the Danish proposal is and what it could mean. And secondly, I'll put the Danish proposal in a European context and discuss some initial reactions to it that we've seen in the previous months. And finally, I'll make some final reflections on the future of extraterritorial asylum approaches in Europe. So to start then with the Danish legislation, as many of you would know, on the 3rd of June this year, the Danish Parliament passed Law 226, a legislative amendment inserting a new paragraph 29 into the Danish Aliens Act, allowing for the transfer of asylum seekers from Denmark to a third country outside the EU for the purpose both of processing their asylum procedure and indeed for the eventual protection of refugees in that third country. Paragraph 29 further provides that transfers must take place under an international agreement between Denmark and this third state, and that asylum seekers are to be transferred, and I quote, unless it would be in breach of Denmark's international obligations. However, as Law 226 envisages the conclusion of an international agreement between these two governments, any concrete instrument will need the approval of the Danish Parliament before implementation. So at the moment, this provision exists on the books, but has yet to be implemented. The law essentially presents Denmark's extraterritorial asylum vision in three phases. Firstly, a pre-transfer screening procedure in Denmark. Secondly, the asylum process itself in the third country. And thirdly, refugee protection in that state. In the law proposal and the passage of the bill, this first phase, the pre-transfer phase, is set out in most detail with the establishment of a two-instance individualized procedure to assess whether the asylum seeker can lawfully be transferred to the third country. So this already can be seen in some distinction to the Pacific solution, for example, which includes summary transfers to Papua New Guinea and Nauru. That being said, the law was, I think, striking in its lack of legal precision. So with respect to the first phase, this screening phase, asylum seekers arriving in Denmark will be individually screened by the Danish Immigration Service with an automatic appeal to the Refugee Appeals Board. The law proposal, however, did not set out in detail which asylum seekers are to be exempted from transfer, but did provide a number of examples, including nationals from the third state itself, asylum seekers with family already in Denmark, and seriously ill individuals. Secondly, the law proposal provided that the full asylum procedure would take place in the third country and that third country should have ratified and in fact respect the 1951 Refugee Convention, including access to a sound asylum procedure. However, the law did not specify which minimum safeguards must be in place for such an asylum procedure, nor the potential discrepancy between the interpretation of international refugee law on the one hand provided by Denmark and on the other hand provided by the third country, which may result in protection gaps. Moreover, and fundamentally, the law proposal did not specify which government would be responsible for the asylum process. Indeed, the law was seemingly adopted on the basis that either Danish asylum authorities or the third country's authorities could assume responsibility for RSD. Thirdly, as I mentioned, the proposal takes an especially narrow view on the rights afforded to those found to be refugees in the third country. So while Law 226 does require the third country to be a party to the 51 Convention and in fact respect the 51 Convention, the explanatory memorandums to the bill only noted that this condition includes that the country must in practice respect the principle of non refoulement. So this is a seemingly very minimalist and rather narrow reading of which refugee rights must be provided here. So I'm thinking here of the extensive catalogue of rights granted under Articles 2 to 34 of the 51 Convention, including, of course, the right to primary education, the right to work, access to housing, freedom of movement, and the right to identity documents. So to move then from the sort of technicalities of the new legal provision, of course, it's quite obvious to refugee lawyers that the Danish proposal represents a rather fundamental shift from the status quo of territorial asylum by building on this gap that Pauline has identified, this gap within the international refugee protection regime, by which the 51 Convention neither ascribes a positive right to seek asylum, nor sets out the conditions in which states can lawfully share responsibility for refugees. And of course, it's important to note at this point that these sort of proposals are not new. Indeed, as early as 1986, Denmark put forward a draft United Nations General Assembly resolution for the establishment of regional United Nations processing centres. And of course, in the European context, the concept of extraterritorial asylum has been raised repeatedly since the European crisis of 2015. It's equally clear that the March 2016 EU-Turkey statement, which of course involves the return from Greece of Syrian asylum seekers to Turkey on the basis of the safe third country concept, is some form of inspiration and guide for the Danish government in this area. Equally, the approaches pursued by Australia in the Pacific and the US in Guantanamo Bay, Cuba, and indeed more recently Guatemala, should of course be seen as guiding the Danish approach. That being said, I do believe the Danish current effort is novel. To my knowledge, it's the first time a European state has legislated for the transfer of asylum seekers beyond Europe's borders for the purpose both of the asylum procedure and protection. And of course, perhaps not surprisingly, the reactions to the passage of the bill were largely negative and indeed dismissive. The European Commission noted that the external processing of asylum claims raises fundamental questions about both access to asylum procedures and access to protection. It is not possible under existing EU rules or proposals under the new Pact for Migration and Asylum. Equally, UNHCR reiterated that the Danish proposal risks undermining the foundation of the international protection system for the world's refugees. And I think it's notable that UNHCR has repeated this criticism subsequently in quite a marked way. On the other hand, of course, the Austrian government expressed positive interest, calling the policy a compelling approach. And of course, in late June of this year, the United Kingdom government introduced legislation of its own, including to provide a basis for the extraterritorial processing of asylum claims in the Nationality and Borders Bill. In August of 2021, the African Union released a press statement strongly condemning Law 226 as, quote, completely unacceptable and an abdication of international responsibility, perhaps an indication that none of the African Union's 55 member states are presently willing to cooperate in the terms that the Danish government envisages. So finally, then, some reflections on the future of extraterritorial asylum approaches. Clearly, the passage of the bill raises a number of legal, policy and operational questions going forward. Chief among them is, of course, whether it will be implemented at all. What's clear, however, is that rather than being a European vision for the reform of asylum policy, this is currently a unilateral Danish vision. It seems to be a unilateral attempt to minimize asylum obligations and indeed to deter future asylum seekers arriving in Denmark. This may be understood as part of what Thomas Gammeltoft and I have called the deterrence paradigm. And it's worth noting that as the Danish policy has been rolled out, the scale of the vision has significantly diminished. So rather than replacing spontaneous asylum with resettlement, as originally outlined, L226 provides for the potentially broad exceptions to transfer, meaning that the number of asylum seekers ultimately transferred is likely to be rather low. A number of open legal questions remain, of course, including whether the centre will fall in a Danish jurisdiction as a matter of European human rights law, the access of monitoring bodies to any such reception centre in a third country, and of course the possibility of return to Denmark should humanitarian considerations require so. Finally, of course, at a broader European level, there is the further pressing question of whether the Danish policy represents a sort of first domino or first mover in the externalization of asylum in Europe. Both legal and policy elements, in my view, would suggest that this question is to be answered in the negative, at least in the short term. So from a legal perspective, firstly, Denmark's opt-out from key parts of the EU asylum acquis would seem to render the passage of the bill legally possible in Denmark, but not in other EU states who are more involved in the EU asylum system. Most notably, of course, the Asylum Procedures Directive provides asylum seekers with a right to remain in the member state until a final decision on protection status is reached. And moreover, under existing safe third country concepts, a connection between the applicant and the third country concerned must exist, on the basis of which it would be reasonable for that person to go to that country. The Danish proposal does not include those safeguards. So while the uptake of Denmark's approach at EU level would seem unlikely, there remains, of course, a possibility that a sort of coalition of the willing may be formed, with certain European states also outside the EU asylum acquis joining Denmark's extraterritorial asylum push. While the current Norwegian government has distanced itself from the Danish approach, the United Kingdom bill, of course, telegraphs the interests of other European states in externalizing to varying degrees asylum procedures and refugee protection. One thing does seem certain, and that is that the vision of externalizing asylum among European states is not going away anytime soon. Thank you very much.
Thank you so much, Nikolas. Great. Bonny, you're next. Do you?
Okay, is everything good?
You're not in presentation mode.
Oh, 1 second.
Now
Yes,
it's
all good.
perfect. Yeah,
you can hear me.
you.
You can see.
All good. Perfect.
All right. Okay. So, good afternoon, everyone. It's wonderful to be here, and thank you, Franziska, for the invitation to today's discussion, and also for the very kind words of introduction. Now, Franziska and I, we collaborated on a special issue on combating human trafficking in Asia, which was published around this time last year. And it's nice to be in touch again, and this time focus on another region. Now, most of my work, I must say, has an Asian focus. It is where I work on migrant rights, not only as a researcher, but also as a practitioner who's mainly involved in trying to change the way that labor migration is done for Asia's low-wage migrant workers. And, you know, they work in Asians' factories that sustain most of the global supply chain. They care for the elderly and many of the aging populations across the region. They toil on distant water fishing fleets. And in this context, the 1951 Refugee Convention and its protocol they don't come up very often. And if they come up at all, it's kind of, you know, very, very, very marginal. So I will start here with the slide. It's a UNHCR graphic from 1982, but it hasn't really changed much for Asia. And, you know, the obvious question is there's one region that's different from the other. Now, in Asia, what's often the case is the state is not party to the Refugee Convention and its protocol, and you see them across. You have Vietnam, Laos, Thailand, Myanmar, Bangladesh, Nepal, India, and so forth. Or the situation is that the state is a party to the convention, the protocol, but they're not implemented so that, you know, treaty law offers little protection to those seeking asylum on the ground. And a good case in point that often comes up is the way by which China treats North Koreans who are officially labeled as economic migrants and then repatriated. Now, this is very problematic because Asia has one of the world's largest refugee populations in the world. UNHCR estimates the number of people of concern in the Asian Pacific to be, you know, around 9 million. It's the population roughly the same as London, including about 4.4 million refugees who are mainly from Afghanistan and Myanmar. That number is going to be higher. Now, in recent months, we're seeing this problem played out in and around Afghanistan as borders are shut and those fleeing are not accepted as de facto refugees. Now, there are reports of refugees seeking out smugglers and traffickers to help them cross the border and then enter a life of irregularity and fear of detection and repatriation. And at the same time, very few governments are speaking openly of negotiating for safe passage for the people of Afghanistan. So for me, today's talk is also a very personal reflection. I made it clear to Franziska when we talked about the talk. Now, I am not an asylum seeker in Europe, but my fate and experience in the UK are intertwined with the popular discourse on asylum and immigration in this country. I'm a new immigrant to the UK, and I also work with community groups that have long assisted newcomers to the community. So with that in mind, I would like to offer a view from the ground, so to speak, and then conclude with some observations for what I think the European developments that Pauline and Nick have talked about so far. What does that mean potentially for the Asian Pacific? Now, I have here a slide of Immigration Removal Center. Now, on the point of territory, refugee protection, human rights, using a spatial perspective that we're doing for today's discussion, let me focus on the other end of the asylum process in chronology, which is at the point of removal. In the UK, there are 11 immigration removal centers. It is a place that deserves more attention in the context of territory and refugee protection. For community workers, it is a place that marks a very, that often marks the end of our interactions with the asylum seekers, and the disconnect is sudden and severe. Now, the question of immigration detention has been examined by the UN human rights mechanism since the late 1990s. The Human Rights Commission, which is the predecessor to the present-day Human Rights Council, requested the Working Group on Arbitrary Detention back in 1997 to devote all necessary attention to reports concerning the situation of immigrants and asylum seekers who are allegedly being held in prolonged administrative custody without the possibility of administrative or judicial remedy. Now, it is perhaps a fact forgotten by history because it happened so long ago, 20 years ago, but the first country visit conducted by the working group under this extended scope of immigration detention centers was actually the UK. The visit took place in September 1998, and the working group came out the same year with several observations and recommendations. And amongst these were recommendations such as the detention of asylum seekers need to be legitimate, necessary, and the shortest period possible. Other measures such as reporting should be considered as alternatives before resorting to administrative detention. Detainees should know they were being detained, the rights, the reasons, and how to exercise their rights. They should have legal aid, and their decisions to be, should go up for independent and partial review. They should not be detained with those convicted of criminal offenses, and detention should not be exercised if the persons are fully absorbed into the society from where they're being removed. And of course, the information on detention should be transparent, and the statistics released to the public. Now, these recommendations were in response to the working group's finding that detentions was often not correlated with the merit of the asylum claim. And they said, often the decision to detain is not determined by the quality of the claim, but rather by the physical consideration of the availability of detention space. Well, since then, since 1998, the situation of human rights in UK's immigration detention centres have received more prominence from both the legal and advocacy community, but problems remain. In 2013, the British Institute for Comparative and International Law came out with a detailed report with 25 safeguarding principles in immigration detention. But even before reaching these detention facilities, the border control enforcement action is traumatic. Many of these primary accounts speak of being treated like criminals, of overtly aggressive tactics, of being, simply confused and feeling degraded and scared. Now, both of these reports that I have on the slide here rightfully emphasize that detainees should know they were detained, the reason for their detention, their rights, and so forth. They should have legal aid and independent review of their case. However, the removal process not only creates fear, but it's also a system built on fear of the perceived arbitrariness of the outcomes. This pervades, I would argue, throughout the asylum process, but is especially prominent at the point around immigration detention. So I have here, I'm going to start with some primary accounts that give some insights into the detention experience. Using these, I would like to tease out elements of some of these working group recommendations and safeguarding principles in the 2013 report that still remain very relevant today. And especially as we look ahead to the proposed, nationality and borders bill that have come up so far in the previous discussions, which is currently under readings in the House of Commons. So I'll start with this case in blue, which is the case that I had on my mind as I put this talk together. And it was told to me. So it was 4 to 5 in the morning, and the family woke up with the agents over their beds. They started to take everything out of closets and dump them on the floor. It was a big mess of things. The family had children, and they didn't go to school that day. The kids did well in school. They never missed school, so the teachers were worried. They called and found out the family had been removed, and that was why the children weren't in school. There are some very collection of primary resources on the web. And the primary account that I just read correlates very well from what we have from other sources, which is that the asylum seekers being treated as criminals at the point of their removal, the act of removing them from their accommodations often recounted as the one where the asylum seekers felt like they had no dignity. And it is also important to point out that children could be part of this process, even though their number in detention have declined. Before the pandemic, it was reported that around 2,000 children every year experience immigration detention. And last year in 2020, the number was 23. But I just want to point out that the children's accounts of this singular event is often jarring in their brutal honesty in how they describe their experience. So a boy of 11 told the children commissioner who looked into the matter in 2011, I believe. And the boy said, there was this woman just shouting at my sister to get up. She was in bed asleep and she's only 5. So she was crying and the woman just kept shouting at her. She didn't have to do that. The search was bad. Why did they have to search my sister? She's only 5. What's the, what is she going to have? They touch you all over and they're rough. It is rude. So actually it's the report by the Children's Commission was 2009. The report was comprehensive and it talked about the treatment of children and young people in these immigration removal centers. And that speak to how many aspects of their treatment in immigration detention were inhumane and in breach of international children's rights. And I have here on the slides the websites where you can read these reports for yourself. But I think it's important to point out for these reasons, families especially fear these operations. And the one case we know where a family with children was removed, the parents asked at every point of interaction with officials in the asylum process, whether or not removal was a possibility. And they were given assurances that family with small children would not be taken into detention center. So when it happened, it was a complete shock to the family and also to the community organizations that the family was indeed removed and went into immigration detention. So cases like this not only underscore the sense of the fear of removal, but also doubts on the integrity of the entire asylum process, that information received is not reliable and are often contradictory. And there's a high degree of arbitrariness at each step of the asylum process in the UK. Now, if I were to stay on the blue case that I originally had, the family, by all accounts, were model new immigrants. The children integrated well, they helped on the community, and most importantly, they always checked in with the home office, at the local police station. So this brings up a contradiction with paragraph 33 of the working group report of 1998, and also with the 2013 report on safeguarding principle, that detention should be the last resort and that it must have a legitimate aim. and alternative and non-custodial measures, such as reporting requirements to the Home Office, should always be considered before resorting to detention. But frequently, many cases of the removal do not meet the criteria of necessity. Now, for instance, does it make sense if I were to tell you that the family was later released from detention on the basis that they were determined to be victims of human trafficking? The underlying question is then, so what was the point of their detention? Now, and if we were to zoom out beyond this one individual family to national numbers, around 40% of asylum seekers detained in the UK go on to be released, and about 40% of families with children in detention are also released. So the broader question is, of course, what is the point of detention being out of necessity when there's a high rate of asylum seekers being released from immigration removal centers? Does it not breach the safeguard of detention not becoming a routine measure when it comes to immigration control, and for detention not to be imposed arbitrarily?
Bonny, can
Yes.
I ask you to wrap it up for
Yes,
this round?
sorry.
You can, of course, save something for later.
Yes, so I just want to say that just 2 days ago, the UK High Court came out with a ruling that foreign victims of trafficking should be given right to remain, leave to remain. This means that victims cannot be repatriated where they might face the risk of being re-trafficked. Now, let me end on this slide, and we can go back and pick up what this means, what I think it means for Asia. But I think this is important. This landmark ruling is important because, you know, first of all, it gives migrant advocates like me, you know, some hope that the UK asylum process will not fail the most vulnerable. But I just want to say that it's not yet certain. This decision is very likely to be challenged by the Home Office, who says that it wants to apply a very narrow scope of who could count as a victim of human trafficking under this decision. For instance, the Home Office has said that maybe it only applies to victims who are pursuing a claim of asylum based on their fear of being re-trafficked. And let me just end here quickly on Pauline's point of the asylum paradox. So much of what I see is that the UK procedure and law has this model asylum seeker in mind, you know, those who enter regularly and those who just say the right thing. So for instance, the Home Office, the question that comes to mind is, we all know about the complexity of a victim of human trafficking. And now, is it going to be purely determined on whether or not they articulate well this fear of being re-trafficked in their interviews? I think that's a very high bar that we know from criminological studies, that it's difficult sometimes to get the information out, but that doesn't mean the claim does not have merit. So let me just end here. Sorry for running over.
Thank you so much, Bonny, for this account. Just a brief remark before we come to Alex, because we already have a question in the Q&A. So to anyone in the audience, feel free to already indicate your questions there, or you can also just indicate if you want to speak up. We can definitely unmute you also to give your comment verbally. But now to our final speaker, Alex Aleinikoff. I'm so happy to give the floor to you.
Thanks very much. I'm going to speak comparatively here a little bit about the US situation compared to Europe. And then also a bit more conceptually, theoretically at the end about what this all means of thinking about territoriality and human rights. You know, first on the US system, Trump's wall kind of said it all, didn't it? That borders matter, and that was an attempt to enclose US territory to delimit US sovereignty. Trump said over and over again, if you don't have borders, you don't have a nation. And then took measures not just at the border, but similar to many of the precedents we've heard here, also to deter people from coming overall. So, and some of these were borrowed by Europe, and I think some were borrowed from Europe. So I don't know if the Danish law, although there had been an earlier Danish law, whether it then became revivified because of what Trump did with the Central American states, or whether Trump's people knew about the earlier Danish law, or certainly the Australian practices or similar attempts by Israel and the like. But there's clearly a borrowing here among the states facing asylum seekers. So Trump entered into agreements with Central American countries that asylum seekers that got to the US could be sent to those countries for adjudication. Very few were actually sent, but it was thought that that had a deterrent benefit to it. That was one of the lesser things Trump did besides building the wall. You will hear sirens here, I think, in Brooklyn, New York, so excuse those. The administration changed the asylum rules to make it harder to apply. It increased, as we've heard in Europe, similarly detention of families. It gave a lot of money to Mexico to enforce its southwest border to stop people coming through Mexico to the US. It created what it called the migrant protection protocols, which are the migration non-protection protocols. What they did is they required asylum seekers who got to the US border to wait in Mexico for their asylum hearing, and then most notoriously separated children from their parents who had come over the border without documents. And that was ultimately set aside when the public outcry was great enough. And some of these other Trump policies actually were stopped in the courts. But this all relied on what Pauline called the asylum paradox. That protection depends on access, but there is no right to access. The Trump administration knew that, and in fact claimed that all their actions were fully compliant with international human law, as the European states do as well. Now, Trump relied on claims of security here. So often anti-immigrant policy is claimed it's needed for economic or welfare reasons of the like, but these efforts were based originally on security. So Trump announced as he ran for president that he would accept no more Muslim refugees because we didn't know who they were and they were probably coming as terrorists to harm us. And then during the 2018 election, the congressional elections in the US, he ranted and raved about the so-called caravans, which were large groups of people coming from Honduras, Guatemala, and El Salvador who came together seeking to come to the US border. And he said these groups were full of criminals and terrorists. And this fits with classical securitization theory. That is that you have elites, political elites in a country labeling a group of immigrants or a situation as raising security concerns that can only be solved through extraordinary measures, through zones of exception, through making exceptions in usual constitutional legal procedures, and also in order to attain electoral success. But many of these so-called security situations are manufactured into a crisis when no crisis exists. That is, the security concern is often pretextual. And that's what happened under the Trump administration. The earlier flows of refugees to the US, even Central Americans, which was a problem for the Obama administration, was never put in security terms. But once you put security into the situation, it then heightens the public concern and then leads to sometimes public acceptance of these extraordinary measures. On top of all this, which didn't work as well as Trump had wanted, then came COVID. And that provided a new pretext, a basis for providing new procedures at the border. And in fact, outside of US law, a new procedure was created that was called expulsion, which doesn't exist in US immigration law, but was based on an order from the Centers for Disease Control under a title of US law that deals with public health. And it said that the CDC, the Centers for Disease Control, could prohibit the entrance of people or goods that were thought to bring serious diseases with them. And the political people in the Trump administration leaned on the CDC to issue this order at the southwest border saying people coming in might be carrying COVID. And if the Border Patrol had to deal with them for any great length, that would give them COVID and it would spread to the US. And at the time it was issued, there was actually much more serious COVID in the US than in Mexico. Under this order, unknown to US law up until this time, hundreds of thousands of persons have been returned, expelled at the US border. And this has meant the end of asylum at the US border. And massive violations of human rights because people have been pushed back to Mexico with no protections whatsoever. This is also you may have seen pictures in the paper about the Haitians who came to the southwest border and were summarily returned, so many of them summarily taken back to Haiti, even though they'd come from Chile, Argentina, other South American countries. This was justified under this COVID order. Now, these measures, these security measures, these COVID measures, are based on this territorial model, right? The idea that borders can be enforced and they should be enforced. Our department that takes care of this is the Department of Homeland Security, homeland, a sense of territory, with the view that territory can be made secure. But I've talked a lot about Trump, but this is not new with Trump, just as Nikolas pointed out about the Danish law. The interdiction of Haitians, there was interdiction of Haitians that started with George Bush and carried through Bill Clinton and carried through Barack Obama. And then later was interdiction of Cubans on the Caribbean, people getting on the boats who tried to get to Florida. They were pushed back. The US Supreme Court, unlike the European Court, said that that complied with US obligations under the Refugee Convention and under US law, which the US Supreme Court said only applied to measures taken in US territorial waters, not on the high seas. And I know there have been European decisions that have taken this case on and expressly said they disagree with this decision, but that is US law currently. And then Obama adopted deterrent measures to stop an earlier Central American flow. It wasn't justified, as I said, in these security terms, but family detention was put in place. Strong statements were made by the Secretary of Homeland Security, don't come. It looked a lot like what Australia told people as well. So I mentioned Trump, but these started before Trump and they've continued. So while President Biden has reversed some of the rules, this Remain in Mexico policy has been stopped. He has not changed the COVID rules adopted under the health laws. And so even under Biden, tens of thousands of people have been turned around at the border with no process. And as I mentioned, was used against the Haitians. Okay, so what follows from all this? Let me make four more general points about territory and human rights. First of all, the border and territory are not coterminous. So if the old model was you had territory, you had a border around the territory, if you build Trump's wall, you can keep people out and have these hermetically sealed territories, letting some people in you want, but most others you keep out. These are no longer coterminous. As I mentioned, the Caribbean interdictions go back many, many years. But even before that, the whole system of visa processing that was put in place in the early 20th century, 100 years ago, showed that the border could be outside the actual territorial border. The use of Mexico to stop the flow, this extraterritorialization also that Nikolas talked about, and even the expansion of expedited removal procedures inside the United States, inside the border, which is pulled the border in, leads to what Ayala Shachar has called the shifting border, a deterritorialized border. So as we talk about territory, it's a little bit old-fashioned, I think, now to think about these rights turning on territory. They really rely on other kinds of processes. Point number two, the recent events, I think, show that attempts to secure the homeland from outside threats will not succeed. Perhaps some people can be deterred from coming, but the pandemic shows that other things will get in. And climate change has made absolutely clear that states cannot isolate themselves from other global processes which will have dramatic impacts on the movement of people. And thirdly, and this is really thinking about the future here, I think we have to think about the role of technology. I mean, we will see the end of paper passports soon, very soon. But more importantly than that, this is a point that Shachar quotes earlier, scholars writing about. The border will become personalized. People will carry the border with them. There'll be a constant monitoring of status and location through your cell phone that you'll have to register when you cross a border or even before you get to the border. And the real dividing line here is going to be between citizen and non-citizen, not inside the country or outside the country, until this technology is ultimately used on citizens, which it may migrate from immigrants to citizens. But this is a complete disassociation of people with the border, a complete dissociation of the border as border of territory. The border will be, as I said, carried by the person. And the major human rights issue to think about in the future, I think, besides these kinds of deterrent modes we've talked about, the detention that Bonny mentioned, all these other current issues are the huge privacy rights that are going to be raised and put in place, really starting with the pandemic, but that the new technology is going to make utterly possible and totally predictable. And if that's true, then it means that Trumpism may be the last gasp of this simplistic understanding of territorial security. It doesn't mean there's going to be a weakening of state control or improvement of human rights, but it does mean that the ground of contestation, if I can use the word ground right in two senses there, that's going to shift away from these sort of border actions. And then my last point, what does this mean for advocacy? I'm wondering, I know that for the advocates, the Danish law, what the US has done in Central America, what Israel proposed to do, I think it was with Rwanda, what Australia's done, Nauru, is seen as anathema, and with good reason. I mean, it's so clear that the places that people are being sent to will not respect their rights adequately, and there won't be measures taken for people who were actually found to be refugees to be resettled in any reasonable way. So we should be incredibly skeptical. But I wonder if advocates are willing to think about offshore processing. Jim Hathaway had a proposal for this many, many years ago. Or I'm thinking about this in terms of Latin America. Should there be, under UNHCR auspices, a regional processing center in Mexico or in Belize or take your place, where asylum seekers could come, processing could occur, and then people recognized as refugees could be allocated to countries they wanted to go to under some kind of quota system. This would stop illegal movement, it would stop smuggling and trafficking, and if there were enough protections for human rights, it might provide a much more orderly way to help people in need. But this, because of the association of offshore processing with the actions of Australia and others, advocates really aren't willing to engage in this. And they kind of go, no, 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 Danish law, no, 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 nothing is acceptable. And I just wonder whether it's time to start thinking about these other kinds of processes that could be made to work and could save people from very dangerous voyages. I guess I'll stop there. Thanks.
Well, thank you so much, Alex. We stop the recording now here.